about the timing of these lawsuits? I mean, does this bother you, or you think it's good that it's early, in your opinion? We were talking about how a lot of it came in towards the end, closer to election. This is a bit out. Any thoughts about that?
Well,
does it matter? Doesn't matter?
Despite the efforts of Nancy Rogers and me to bring the attorneys together to try to talk and avoid litigation, we also knew that it was best to plan for litigation. My thought had been to get our directives, our advisories done early. That way, and we have people all over the country who look at these for whatever campaign purposes that they have. That way it gave them a chance to look at it. If they had a problem with it, the lawsuits could be filed early, because we still will get the bulk of our voters on election day. And we want the rules in place, the poll workers well trained, so that it's the least amount of difficulty for the voters. The voters can have a good experience on election day, and we can make sure that we count every vote. One thing I should probably point out is, I've brought this to the attention of a number of people, but this year there's a poll worker quick reference guide that we have supplied to all the boards of elections, and each poll worker in the state will get one of these, plus these will be available in polling places. So our goal with this is we're dealing with issues that we didn't have in 2004, such as voter identification, new types of voting machines, and it seems that we are in a more litigious era when it comes to elections. So every poll worker will have the same basic information about how all of this should work at the polling place, especially when it comes to voter identification and provisional voting, because provisional voting is something that oftentimes is used when it's not necessary, and the more provisional ballots you have, the more it ties up the poll workers' time, the longer it makes the lines because of the length of time it takes to vote provisionally, and the more work it creates for boards of elections after the election in attempting to determine which votes should also go into the official canvass, and the more difficulty it creates for voters.
David heard back from Morgan County, and they do have ballots.
Yes, we just got off the phone with Morgan County. They confirmed they do have ballots. They did not get their printed ballots from the actual printer, so they went ahead, had the ballot layout, made sure that they had actual ballots. Should anyone come in, they can vote those.
Have you heard whether Madison County is appealing the decision?
I don't know that there's been an appeal filed from Judge Glynn's decision by Madison County, but we can follow up and let you know.
Thanks.
I've seen so many different pleadings in my emails.
Where do we stand in terms of the litigation involving the decaying absentee ballot application?
Our brief was filed in that matter yesterday. My understanding, in the second piece of litigation, Bill Todd missed the filing deadline. I would expect that the Supreme Court would dismiss that action without a brief from the relators in that case.
So you don't anticipate an oral argument or anything?
My experience with these expedited election cases is generally they don't conduct oral arguments. And this one, I don't think there was quite the urgency on this one as there was with the 5-day window overlap because of the vote actually starting today.
Have you begun to contact some of those voters who had the problems with their ballots through your new web tool and notifying with your new web tool?
Well, I don't think any boards of elections have asked us for that assistance. It's been up and ready to go, but in my experience visiting boards of elections, this hasn't been a real great concern for them. They routinely have to return absentee ballot applications for lots of other reasons, and they've been handling it and taking it in stride with everything else. And if the boards had wanted our assistance, I mean, it's there and it's able to be provided, but for instance, my discussions with Jane Platten in Cuyahoga County, they sent voters back the actual application along with the new form and with a special envelope, and they received more than half of those back corrected from the voters. So it really hasn't been quite the furor that some have expected.
You mentioned not being philosophically opposed to observers for in-person absentee voting. What would be the grounds for the appeal of Judge Smith's hearing?
The grounds for the appeal are more so the precedent that's created when a federal court abstains on the federal issues and then proceeds to rule on state law issues. If you look at the transcript and the written decision, there was no federal law basis for stepping in and changing the application of Ohio law. It seemed to be more of a fairness argument, and while I would very much like to be fair and offer offer observer status like we do at the election, I cannot substitute my judgment for the law, and the law is silent on this. In fact, the law states that when early voting takes place at a Board of Elections, the Board of Elections is treated as a polling location. And you go to other statutes that prohibit loitering in polling locations. So when there's no specific authorization for an observer, anyone just standing around watching at a Board of Elections for voters to vote under current law is treated as someone who is at a polling location who shouldn't be there and who could be interfering with the ability of people to vote. So once again, the legislature's had a number of opportunities to deal with this law, to plan ahead for the 2008 election, and apparently they missed this opportunity or decided that it wasn't necessary. And it's unfortunate now that we're at a last-minute situation where the boards of elections have a lot of things on their plates to be prepared for the November election, and this is yet one more set of instructions that they had to get at the 11th hour and to be ready to go and to be complying with all the rules and regulations for early voting starting this morning.
You've come to the legislature with a number of recommendations on various issues. Is that something that you recommended? They deal with the poll worker situation and absentee balloting? I'm not poll worker, observer.
No, that was not one of our recommendations.
Okay.
And I think where we are right now with the way the law is, and then the latest change, well, the change that was made in 2005 and 2006 for no-fault absentee voting is that putting this into effect in a presidential election with high voter turnout, I think that I hope that the legislature will work with us on making some changes so that we can make this as convenient as possible to voters and able to be easily administered by boards.